Hello, and thank you so much to the Center for American Progress for bringing us all together and creating space to talk about these critical cases. And thank you to all the advocates, some of whom you will hear from today, who work every day on behalf of the American people, the workers, voters, parents, families, communities, small business owners, to make sure their voices are heard in the courts and in the halls of government. I'm Skye Perryman, the president and CEO of Democracy Forward, a national legal organization that brings the power of people to courts across the country to advance democracy. Next week, the United States Supreme Court will hear oral arguments in the Loper Bright Relentless set of cases. These cases could radically alter the ability of our federal government and overall system of democracy to deliver for the American people. So what is Loper Bright Relentless all about anyway? Well, on their face, they are two cases that concern the validity of a federal regulation issued by the National Marine Fisheries Service in implementing a law that was passed by Congress in 1976 to preserve the nation's fishing resources. Commercial fisheries in New England have challenged this regulation that was issued that requires fisheries to contribute financially to monitoring the program through paying salaries of federal observers who board vessels to collect data. The important thing is that in both the Loper case, which arose from the DC Circuit, and in the Relentless case, which arises from the First Circuit Court of Appeals, two courts of appeals found that the fisheries regulations that were issued by the federal government were valid. And in doing so, the courts found that the agency reasonably interpreted the law that Congress passed and the authority that Congress provided the agency in implementing the regulation. To support their findings, these courts of appeals relied on a longstanding principle of law that we call Chevron deference, which stands for the proposition that when Congress passes a law that contains ambiguous or broad or unclear language, federal agencies are entitled to deference in the way that they interpret the law, as long as their interpretation is reasonable. In asking the Supreme Court to reverse these courts of appeals decisions and to vacate the regulation, the petitioners in these cases are asking the Supreme Court to overrule the Chevron doctrine, which is this principle that federal agencies have relied on for many years to regulate, and that the American people have relied on to have a more stable legal and regulatory environment. From a legal perspective, Chevron deference, which we'll talk about today, has been a backbone of administrative law for nearly 4 decades, and the principles embedded in this doctrine have been utilized by courts for nearly a century. This doctrine has enabled our federal government and our federal agencies to use their subject matter expertise in interpreting a range of laws passed by Congress without interference from the courts substituting their own interpretations for the interpretations of agency experts. This has not only enabled our agencies to do the work of the American people, from keeping our water and food supplies safe, to encouraging small business lending, to advancing healthcare for millions, to protecting public health, and to enhancing the public safety, and so much more. But it has also promoted stability in our legal and regulatory system that is necessary for our overall economy to thrive. For example, for small businesses, which represent 99% of all businesses in the United States, to be able to grow and to thrive and compete, they need regulatory stability. And without the Chevron doctrine, the courts would substitute their own views for the experience of agencies, and in doing so, they would disrupt the uniform interpretation of these laws and regulations. Could you imagine what our system of government would look like if a regulation that was interpreted differently across each of the 13 federal courts of appeals and all of the 94 federal district courts? This is why you've seen more than 250,000 small businesses, which are the backbone of the American economy, weighing in at the court and urging it to uphold the rule of law that has been the law for nearly 4 decades. So before going into our panel, where you'll learn more about these critical cases, I wanted to dispel 2 what I call Chevron myths, and then provide some information about how these cases relate to our overall democracy and the health of our democratic system in this pivotal moment we find ourselves in as a nation. Myth number 1 is that Chevron deference, or deferring to federal agencies' sort of interpretations and expertise in some cases, has led to federal power run amok. This is a myth and it is wrong. Chevron deference does not mean that there is no check on federal agencies or on the way they interpret laws or on the way that they regulate parties. Under our system of government, agencies have to regulate pursuant to the laws passed by Congress. And if that law is passed is unclear or ambiguous, the agency does have the ability to interpret the law under Chevron deference in implementing regulations. But that interpretation has to be reasonable. It is important to remember that in many cases, Congress itself will purposely use broader language so as to not to be too prescriptive and allow agency expertise to determine the details of the execution and implementation. So the fear that Chevron deference has led to unchecked federal power is quite misguided. And indeed, many of the speakers that you will hear from today on this panel have challenged agency action in court when it crosses legal lines, and they have done so within the existing Chevron framework. So that's one myth that we should just dispel. Chevron does not mean federal power run amok. The other myth that it's important to dispel is something that some folks will say that under Chevron, political ideology as opposed to expertise is actually what has ruled our federal agencies and policymaking. This is also not true. Research has shown that when courts are applying Chevron deference and deferring to our federal administrative agencies in appropriate circumstances, that this has been critical to keeping ideologies or specific preferences or views of individual judges out of our federal regulatory system. Chevron deference has been shown to curb the judiciary from imposing its own ideological or policy-driven perspectives when interpreting regulations. There is data that has shown that when an agency issues a conservative, maybe ideologically conservative interpretation of a law, and an ideologically liberal judge or judicial panel using Chevron deference considers that it often agrees with the interpretation of the agency about 51% of the time. But when not applying Chevron, that number drops to about 18%. The same is true on the flip side. Ideologically conservative judicial panels respond similarly when they're looking at liberal interpretations of a statute or ones that might be characterized as more liberal. When faced with those interpretations, those panels often, when applying Chevron, will agree with the agency's interpretation about 66% of the time. But when not applying these longstanding principles of law, that number drops to about 18%. So this longstanding principle of law, Chevron deference, places an important limit on the federal judiciary in ensuring that our regulations are driven by policy expertise and by the intent of Congress and not individual judicial preferences or orientations. So this, of course, leads me to what the Loper and Relentless cases are really about. They are another substantial and concerning attempt by special interest and far-right actors to overturn a critical check on judicial power and to undermine a federal government that is able to work for all Americans. It is no surprise that the Loper and Relentless cases that you will hear about today are being pushed by the same groups who are involved in some of the most harmful and disruptive efforts to undermine our democracy at this moment. Groups that have been behind promoting the so-called big lie, the lawyer who was indicted for election interference in Georgia, groups that were behind the legal effort to overturn Roe versus Wade, and that are now seeking to undermine the Food and Drug Administration's authority to approve medication abortion in their litigation in the Fifth Circuit. These are the same groups that are backing the Loper and Relentless cases. If this was just about a wonky policy dispute, you would not see this type of engagement. These cases are about our democracy and about the well-being of people and about attacks on the very idea of a government that is to work for all people. Like in cases such as Dobbs, here again with Loper and Relentless, we have two courts of appeals that applied long-standing judicial precedent, the Chevron doctrine, and the US Supreme Court nevertheless accepted the invitation from far-right groups and other interests to reconsider decades of legal precedent. As with the issues we've seen arising at the court on abortion or racial equity programs and so much more, these far-right groups are again asking the court to disrupt almost 4 decades of precedent and seeking to create an American system of government that only works for some and not for all. So as we move into the panel today, it is important to remember that we are not powerless. We have seen the broad and ideologically diverse array of people and communities in America weigh in at the Supreme Court on these cases. From workers to small business interests, to civil rights advocates, to conservationists, to science and health care professionals, to legal scholars. Many in our society are weighing in to urge the court to affirm this longstanding cases. These cases indeed arise at a pivotal moment in our democracy, and they are about far more than principles of administrative law. They are about the ability of our government to deliver for people and for the American people's needs to be met. So we are here today to be reminded that we are not powerless. We have the ability to mobilize, to be educated, and to push back. And our democracy and the well-being of people depend on this work. So thank you for attending and for the work you do. And I can think of no better panel than the one we have today to discuss what's at stake and what we can do in this moment. So without further ado, let me turn it back over to Devin Ombris from the Center for American Progress.
Thank you so much, Skye, for your important insights, and welcome to those of you who are joining us virtually. I'd like to remind you that you are welcome to submit a question in the Q&A tab below as we go on. And coming to discuss administrative law, I'm so excited for you to be here. I hope you're excited to be here too. It's not something that's regularly discussed in the general zeitgeist, given all of the other things that are happening within the universe of the courts, but administrative law is crucially important because it touches everything. It is the thing that has underpinned modern functional governance for a century, and with the oral argument coming up in Loper Bright and Relentless next week, the nation stands on the precipice of the Supreme Court deciding that federal agencies do not have the authority to protect workers in the workplace, to enforce labor laws, to allow financial regulators to enforce laws against fraudsters and financial predators, to protect the environment, to ensure that we have safe food and drugs, and so much more. Not to include also for administering critical healthcare services for seniors. So joining us today is an absolute all-star group of panelists from Earth Justice, Kirti Datla, the Director of Strategic Legal Advocacy, Professor Craig Green, the Charles Klein Professor of Law and Government at Temple Law, Sarah Summers, the Legal Director at the National Health Law Program, and Andrew Strom, Associate General Counsel, SEIU, Local 32 BJ. So to begin, I'd like to turn to Professor Green. If you can set the stage for us for what Chevron deference has meant over the course of the last 40 years and the broader aspects of this conservative effort to undermine the ability of agencies to protect Americans.
Yeah, thanks for having me. I'll start with the last first. I mean, we're looking at probably the biggest administrative law case in decades. It's going to create a broad pro-business, anti-government precedent, last a generation, hurting public policy, national governance, risking American lives. And just the way Skye introduced it, these cases on the one hand are really tiny about whether a particular agency can make fishers pay for monitors at sea. But it's also an enormous case, questioning whether any federal agencies can function as they have done since FDR, the New Deal, or the 30s. And the reason is because Congress has regulated lots of different areas for nearly a century using the same basic pattern. Over and over, Congress recognizes some big public problem. They create an agency, and they give that agency statutory authority and instructions to fix it. Now, Congress does this because agencies have more expertise, they're more specialized, they're more flexible, so they can address new problems and crises that inevitably arise over time that Congress can't foresee and they can't act in time. So all these agencies, they have to interpret and implement their congressional mandate. And since 1984, the Chevron case, or 1944, 1827, you can fight about the dates, but it's old. Since a long time, federal courts have given agencies deference to interpret their statutes and do their job. And this case, I like the idea of calling it the Relentless case. The Relentless case could hamstring agencies across the country, and it's all the same list. Every agency, not just the National Marine Fisheries Service, Food and Drug Safety, Clean Air and Water, Nuclear Power, Safe Airlines, Consumer Protection, Unions, Banking, Federal Financial Markets, Mortgages, Student Loans, COVID, Future Pandemics, cell phones, healthcare, really, you name it. And yes, also the power to make fishers pay for monitors at sea. But all these things are bundled together. That's the important point. This idea of deference is a fundamental mechanism for agencies to do their job, all the agencies, to do all their jobs. And the Supreme Court is probably going to say that the past 40 years or 100 years or more of federal government are unconstitutional and violate separation of powers. And somehow nobody really noticed it until the current 6-3 conservative supermajority came to town. And I think that's really why so wide a swath of American lawyers and public activists and people who care about government democracy, why they're all focused on this particular moment in Supreme Court history.
Yeah, that is incredible. Thank you, Craig. And, I take note that the court didn't take up the narrow question to strike down this narrow regulation. They took the question of whether to strike down all of Chevron. And that's a big tell, I think. Turning to you, Ms. Statla, Earth Justice is an absolutely incredible organization that fights to ensure environmental regulations stand to protect not just our ecosystems, but the health and well-being of Americans. Can you discuss in some detail what the implications of overturning Chevron are for doing just that, being able to have a healthy environment to live in, for smog dispersal and pollution, and what really is at stake?
Sure, thanks. Thanks for having me. I think it might be helpful for me to talk a little bit about how environmental groups like ours have been thinking about the problem to kind of help set the stakes. So as I think was sort of implicit in a lot of what Craig said, there has been a sort of counter reaction to the Chevron decision almost immediately after it was issued in the 1980s. And so it isn't like it's a surprise that we've reached this moment. I think it was always a question of when, not if, especially once the tenor of the courts shifted. So as I think some folks might know, the Supreme Court itself has not relied on Chevron to reach a decision to uphold a regulation since 2016. And that has, I think, sent a signal to folks who work in the environmental arena, and I'm sure in the other areas that we'll talk about today, that that needs to be reckoned with. And so actually for quite a long time, I think folks in this space and others have been encouraging agencies at the time they're writing a regulation not to assume that they'll be able to rely on Chevron deference to have a regulation upheld, and have been encouraging litigators in their briefing defending or challenging regulations not to rely on Chevron. So I don't want to take away anything from what Craig said about the stakes, which I think are incredibly important. But I think the way I think about them, and many in the environmental community have been thinking about them, is to kind of try and keep separate in your mind why people are trying to overturn Chevron, what they think they're going to get out of it, and that aligns completely with what Craig and Skye have said already. And then on the ground, how's that going to shake out? And so I guess the point I'm making is that this is a threat that's been looming for some time. People have been reacting to it and trying to deal with it for some time to mitigate the effects of the threat. And that I don't want to paint a rosy picture and say everything will be fine, but I do want to say that we at least don't think of overturning Chevron as a we'll always lose, but we think of it as there's a reason other people who disagree with environmental regulations are pushing so hard to overrule Chevron, and it's because they think they will win more often, and they wouldn't be pouring so much money and time and energy into that effort if they didn't think that was a pretty safe bet on their side. So I just want to make sure at least our view of the stakes of the case are out there. And I guess the additional thing I would say is that if you look at the kinds of, if you look at the regulation in this case, the Supreme Court has decided it doesn't actually care about the outcome on that regulatory question, but the issue is about gathering necessary data to manage fisheries for the benefit of fishermen without the data that the observers, so these are like folks who are placed on boats to get objective third-party data that the government can then use to set fishing levels and comply with all the other requirements under the Act. If you don't have sufficient data under the Act, that means you can't set fishing limits high, like as high as fishermen would want, because you don't know whether they'll be overfishing or not. So better data actually often leads to better fishing or more fishing, which is better for fishermen. So it's not like this is some sort of, to talk about myths like Sky did. This is not an anti-fisherman regulation. This is about making this statute work, which protects both the people in the fishing industry and all of us who depend on our fisheries being sustainably managed. You see this replicated across a ton of environmental regulations. So just like think about the kinds of regulations that have been upheld under Chevron in the past that would then be sort of, in a post-Chevron world, you wouldn't have the benefit of the Chevron sort of neutral principles rule, and you might have a cherry-picked forum before a district court judge who doesn't have a favorable view of any environmental regulations, for example. So just to give two kind of big examples, the Endangered Species Act, the meaning of the word take, which is sort of a central, you're not supposed to take endangered species, so you're not supposed to kill, harm, et cetera, an endangered species. So that's like the crux of the act that the Supreme Court applied Chevron deference to uphold the agency's view of the meaning of that term. And I think the question to ask yourself is, do you think there's any value in courts seeing that agencies have expertise, both technical and learned expertise over time in interpreting that word? Or do you think that courts are fully equipped to decide the meaning of that term on their own? And who's better positioned, both expertise-wise and accountability-wise? Another example is the phrase best technology available under the Clean Water Act. Again, sort of crucial term in the way the Act works, a technical term, and you can ask yourself whether you think who's best positioned to answer what those words mean. So those are the kinds of terms and the kinds of statutes that will be affected by the decision in this case. And I think I'll stop there.
Thanks so much, Kirti. That's bracing, and there's a distinct irony into the challenge here, because if these monitors are taken off the boats and not providing the good data, they're going to perchance set the fishing limits low, at which point we'll see these same actors come back and sue the National Marine Fisheries Service for saying that they're set arbitrarily low, and it's going to fall into a cycle of inexorable overfishing, and it's going to be environmentally disastrous. So it's both sides of the coin that we're trying to fight against, because the outcome of this is going to lead to just worse and worse outcomes, not only for the environment, not only for the American people, but the very people who are suing in the first place here. So with that, I'd like to turn to Andrew Strom with SEIU. I'd like to give you a quote that I heard from the former Deputy Solicitor of Labor under the Trump administration, who said, and I quote, "Overtime and tipped wages are entirely dependent on Chevron. Tipped hourly workers are not the only ones dependent on Chevron, and often the very ability of the National Labor Relations Board to enforce labor laws is Chevron dependent." So between cases like this and cases like Jarkessi, which was argued last month, how are these potentially adverse rulings going to affect worker protections across the country?
Yeah, I mean, they're absolutely going to. I think, let me just start with a quote from Justice Kagan, who often has, she has an excellent way with words. This is what she said in West Virginia versus EPA about the importance of these administrative agencies. Here's the quote. "Over time, the administrative delegations Congress has made have helped build a modern nation. Congress wanted fewer workers killed in industrial accidents. They wanted to prevent plane crashes and reduce the deadliness of car wrecks. They wanted to ensure that consumer products didn't catch fire. They wanted to stop the routine adulteration of food and improve the safety and efficacy of medications. And it wanted cleaner air and water. If an American could go back in time, she might be astonished by how much progress has occurred in all these areas. It didn't happen through legislation alone. It happened because Congress gave broad-ranging powers to administrative agencies, and those agencies then filled in, rule by rule, Congress's policy outlines." So getting to your specific questions, Under the Fair Labor Standards Act, which is the law that regulates minimum wage and overtime, the Fair Labor Standards Act delegated to the Department of Labor the authority to make regulations defining some of these terms. And one of the terms, for example, is the people who are exempt from being paid overtime are, among others, bona fide executives. And so since the earliest days of the Fair Labor Standards Act, what the Department of Labor has decided is that one way to tell whether somebody's a bona fide executive is by how much they're paid. And if they're paid at a very low wage, then they're not a bona fide executive. But because of, administrative inertia or politics or who knows what, the threshold at which, so the Department of Labor had set a threshold and said, if you're paid below this amount, then you can't be considered a bona fide executive. And that amount over time hadn't kept up with inflation, and it had gotten lower and lower. And then during the Obama years, the Obama administration said, you know what, we need to reset this rate, right? We need to set it, because it was at that time, it was an annual salary of $23,000 a year was enough to make you, that was the cutoff, which was meaningless, right? Because $23,000 was below minimum wage, actually, in a couple of states. And they said, we're going to raise that to $913 a week, or $47,000 a year, right? So that if you want to be considered an executive, and that was the 40th percentile of the wage rate, right? So saying if you want to call somebody an executive, you've got to pay them at least $47,000 a year. And what happened there was, and I think one of the things that's important to note here is, whatever term you use, whether it's Chevron deference or major questions, or there's or even sometimes allegedly applying Chevron deference, which is what happened in that case. When you have right-wing judges substituting their views for the views of an agency, that's going to lead to a bad outcome. And that's what happened in that case. Was there was forum shopping. The law was challenged. It went to a right-wing judge, and a right-wing judge struck it down and said, well, you can't define an executive by how much money they make. You can only define an executive by their duties, which is, contrary, again, as I said, to 60 years of practice, and also common sense, right? Because common sense tells you that if somebody's being paid $25,000 a year, they're not an executive. And so that was one example. You mentioned the tip rule. The Biden administration recently enacted a tip wage rule that said that if you're going to be paid, if you consider a tipped employee, you can't be required to do more than 20% of your time doing non-tipped work. What happens in a lot of restaurants is that you have the wait staff doing a lot of setup work before the customers come in. And they're told, you have to fold napkins, or you have to, refill the salt shakers, or whatever else they have to do, or, before the customers come in. And again, the regulation said if you're doing that more than 20% of your time, then you can't take the tip credit. And that's also being challenged. And I think, the same thing with the National Labor Relations Act. One of the points, about whether this is a 40-year-old, whether Chevron's a 40-year-old rule, or a much older rule. When Chevron was, after Chevron passed, Chevron was a unanimous decision. And after Chevron was passed, Justice Stevens was once asked about it, and he said it was, quote, simply a restatement of existing law, nothing more or less. And the cases he cited, a number, one of them was from the National Labor Relations Act, a 1944 case. And in 1945, in upholding an interpretation of the National Labor Relations Act by the NLRB, the court said that the act left to the board the work of applying the Act's general prohibitory language in the light of the infinite combinations of events which might be charged as violative of its terms. And that's a really important point, right? I mean, it's fundamentally impractical to expect that Congress can ever anticipate in statute all the issues that will arise about ways that entities can violate those statutes. And you have to give agencies the flexibility to apply broad terms to specific conduct, because otherwise, it's a recipe for paralysis. I mean, I could go on, but maybe I should stop.
Thank you, Andrew. Appreciate it. No, so many excellent points there about how, people, just working people in America are going to be undermined if at left and right, who are already subject to so many issues like wage theft and underpayment. It's really going to be painful on the folks who need it the most. So I want to turn to Ms. Summers of the National Health Law Program. You all submitted an amicus brief in this case and argued that, quote, given the amount of money often at stake in challenges to Medicare and Medicaid rules, a post-Chevron litigation tsunami would seem all but guaranteed. Could you talk a little bit about these destabilizing forces and go into how it would really destabilize the healthcare system? I know it's super wonky, and if we can just kind of describe how this is going to affect everyday Americans, that would be fantastic.
Yeah, thank you so much, Devin, and thanks for having me on the panel. As Devin previewed, I'm focusing on regulation by the Department of Health and Human Services, particularly the Centers for Medicare and Medicaid Services, or CMS, which administers Medicare and Medicaid programs, among other things as well. And even if you're not familiar with the programs, it's probably no surprise to you, they are vast, extremely complex, require significant oversight, and just present thousands of hyper-technical issues that require significant expertise to really understand and to actually regulate. CMS publishes, over the last few years, on the average, a new notice of proposed rulemaking every 2 weeks. So think about just, the level of detail and reach that they're getting into there. And nearly half the population are enrolled in Medicaid or Medicare, and many more people beyond that are affected by it if you have family members on Medicare or Medicaid, or if you use, a hospital or other kind of health facility that primarily is regulated by Medicare and is also subject to Medicaid requirements. This just touches everybody. But unlike some of the more the issues that may map a little bit more ideologically or have a little bit more public appeal, a lot of this the sneakiness of this whole attack here is that it's really boring and arcane. And you can, as Devin is eyeing me closely, you could put people to sleep by getting into too much detail. So I'm going to be careful. But, let's just talk about what's going to happen if there is no Chevron deference. First of all, it's just going to be a level of impracticability and just, the inability of the agencies and the entities they regulate to really work well. It's not that Congress doesn't want to or that they're lazy. They don't have the time to draft and update and amend and modify the Medicaid and Medicare statutes to address every single aspect of the program. There's just not enough hours in the day, people on the ground. So you're going to have, it's just not really practical to say, well, Congress should do their job. You're going to have a real lack of consistency, as was pointed out earlier. If you have every circuit and every district court taking another crack at what it means to have, to regulate a community health needs assessment for a hospital, then you're going to have, lack of consistency across jurisdictions. And even think about hospital systems or insurance programs that span different states. Just think about, how difficult that's really going to be for things to work well. And then, as Devin previewed, you end Chevron, every one of these thousands of cases that have addressed billions of dollars and millions of people, you could open all of that up again. Everything that we thought was settled by the DC Circuit or the Supreme Court or any of the circuits, you want to go back and do it again? You want to do it in every state? Why not? What do you have to lose? Because there's much less certainty. And just this area too, it's so complex and technical. If you read any one of these cases, just to give you a preview at risk of like putting you to sleep or watching the participant numbers drop, this is a typical issue in one of these cases. Whether CMS exceeded its authority by adopting the OMB's metropolitan statistical area definition as a proxy for geographic area for the purpose of adjusting hospital payment rates for Medicare payments to adjust the wages for different geographic areas. Are you still alive? Are you still with me? Maybe not. Does the court want to do this? No. Does the court have time to do this? Can the court do this? I guess, but if it wants to do nothing else, then it can spend all its time on that. What the court wants to do and should be able to do is to be able to say, okay, the agency with its actuaries, with its experts, with its experienced people who are knowledgeable about hospital regulation, can I look at what they did? Does that seem plausible? Does the statute address it? Heck no. Is it plausible? Is it reasonable? Sure. Did the agency support it with data and with the proper comment period and everything? Sure. Okay, maybe we might say something different, but we're going to go with that. That's how it's going to work well. And the thing is, do the entities who are attacking Chevron that Sky previewed for us at the beginning, do they care about metropolitan statistical areas, geographic areas, community needs assessments, feeding rules in nursing homes? No, there's no ideological bent to that. There's not much to it. But in the interest of like sticking a spoke in the wheel, slowing down the system, making things work more poorly, it's just part of the narrative. Well, government doesn't work, let's just get it out of the way. But, your average person may be susceptible to that narrative, oh, government, it's just a pain, it gets in the way. But people want hospitals to work. People want their insurance to work. People want, clinicians to be regulated. People want these things to function. It's literally life and death. So while back to what Kirti made the point, like for us who litigate in this area, Chevron is sometimes we're for it, sometimes we're against it. Sometimes we want the agency's determination to prevail. Sometimes we're arguing against it. But everybody wants a baseline. Everybody wants a rule. Except for those that don't have an interest in the system working well. So I'll leave it at that so we can have more of a conversation. But that's the report from Medicaid, Medicare world.
No, and that is incredibly helpful. I love the examples, and the fact that it does fit that narrative. The folks who are pushing this agenda are saying, well, government doesn't work. Let me hit it with a hammer to see if it works. Oh, I'm going to hit it with a hammer again. It's like calling a plumber. Instead of wrenches, they bring a sledgehammer and hit your toilet with it and say, man, toilets are terrible. They don't work at all. So I really appreciate that and all of your insights. I want to just briefly do a quick round robin, 1 or 2 sentences going off of something that Kirti said. Why are people trying to overturn Chevron? And if you all could just give me 1 or 2 sentences about why is this happening? What is the purpose of it all? And I'll start with Craig.
Yeah, I think these are folks who would love to repeal big statutes that do big things, including all the ones we've mentioned, including environmental statutes, and they can. I think Sarah was saying this very well. Just jam it up and break it and make agencies scared to do things to keep people safe and think that they're going to be mired in acres of litigation. And so I think it really is an effort to swat at government with a big hammer, a sledgehammer, to borrow that other metaphor. I think it's an anti-governmental, anti-administrative, anti-public policy, pro-business, private power type of decision. That's a long sentence.
No, that's a great sentence, and I mean, I think it's right. Just removing the ability to protect American people. Andrew, do you have any additional thoughts you want to add to that?
Yeah, I think it's because they can't win elections, right? Because really one of the issues is that, and one of their critiques of it, frankly, is that the agencies are carrying out the policies that the administration wants. And they view that as, grounds for criticism, right? Do they say, oh, the agencies change from administration, they change their policy depending on who the president is. But that's a feature, that's not a bug, right? That means that they're responsive, the agencies are responsive to the political will. And they can't, these people, these business interests, they can't, their viewpoint, right, that, we should just let the free market run wild is unpopular. people understand that you need to rein those, you can't just be like whatever the most profitable thing is, right? Without regard for the effects on workers, the effects on the environment, the effects on all of us, the consumer, that doesn't work. And so they can't win elections, and they appeal to right-wing judges, who find their sort of libertarian fantasy appealing.
Fair. Kirti?
Yeah, I guess I'd say two things. One, I think might just be putting that point a little differently, which is, it's been a while since I've taken like a game theory or political science class, but if you think about when Chevron makes the most difference, there's lots of ways to overturn a regulation, right? You can, Congress can, of course, repeal a regulation. The president can, or the, political appointees within the executive branch can suggest the initiation of a repeal of a rule. Obviously, anybody can petition to start that process too. And so if you want Chevron really badly, presumably that means you think you can't get what you want through Congress or the president, and you want to increase the odds of getting what you want through the courts. So that's, I think, one way to think about it. And I guess the other thing, if it's not too flippant to say this, is, I do kind of wonder what the answer would be if somebody actually just went and asked, the CEOs of the people who signed the amicus brief for, the Chamber of Commerce. Like, I actually don't know if their general counsels really do want to overturn Chevron, because I think, as Sarah said, it's going to make things, there's going to be more uncertainty. And my understanding is that regulated entities appreciate certainty and predictability. But I do wish people would ask, because I don't think it's that the CEO of, whatever company has a deeply held view of what Article 3 of the Constitution requires. I think you'll get a different answer. And I guess the other way to know that is to just look at the amicus briefs lined up on the other side. It's groups like hedge funds, it's groups like financial processing firms, it's e-cigarette manufacturers. These are, again, not people who, are acting based on an objective, like neutrally held view of the original meaning of the Constitution. They're acting based on rational business interests, and that's why they're pushing so hard to overturn Chevron, is because they think they'll do better in a world where Chevron doesn't exist.
Yeah. So not necessarily looking out for the health, safety, and well-being of the American people. Sarah.
Yeah, well, that and cleanup, I think I'll just kind of amplify a couple things. I think what Craig says is totally right. Cowing agencies is a real thing. We see it happen with CMS. Fear of litigation can really bring an agency to heel. And imagine, litigation on steroids times 100 for all of these issues. And I think too that it is interesting to look at. I think we can paste the link from SCOTUS blog that has the links of the amici, like things like they're think tank types like Manhattan Institute and the like, but there's also like America First Policy Institute, Little Sisters of the Poor, electric nicotine delivery system industry, some of whom aren't it's got to be ideological. It's just part of the general. Oh, there you go. Thanks. Thanks for putting that in the chat. And Sports Shooting Foundation, things that maybe it's just like ideological, vaguely libertarian anti-government types of philosophy.
Fair. Well, thank you guys so much. We are going to move into the question and answer from the audience section. We just burned through that 40 minutes. So thank you guys for making administrative law exciting. My first question is for Skye, and this does indeed come from the audience. Wanted to continue on from Craig's point about this big effort being pushed by pro-business efforts. And Skye, I know you all submitted amici from a small business perspective. Could you speak a little bit to the effect on small and family-owned businesses, since this is clearly being pushed by big special interest groups?
Yes, I mean, what we found in our brief that was submitted on behalf of institutions that represent more than 250,000 small businesses in the United States is that really regulatory certainty is very important for small businesses to be able to compete in our economy. They're the backbone of our economy, and they need the certainty and the stability to compete. Bigger institutions do have large legal departments and other types of mechanisms to deal with certain regulatory disruptions, even though I think, and you see this in some of the briefs that were filed in favor of the government, I think you would even see a lot of large disruptions even among those larger institutions, notwithstanding some interest groups that are seeking to suggest otherwise. But for small businesses, it is absolutely critical for them to be on a level playing field, to have any ability to be able to sustain their communities and sustain their businesses. That there be certainty and stability in regulation. That doesn't mean that things are never going to change, but it does mean that if you had a situation, which is what we fear if Chevron is overturned, where litigants are just able to flood the courts with lots of litigation all around the country, where you have multiple different courts with multiple different interpretations of highly technical matters that are really important to our small businesses and to regulated industries, that you can see a lot of economic disruption. And so that's why you see such a robust coalition that have weighed in. It is why I think in this case, you can't put things in a box and say, well, clearly the Loper and Relentless positions are the positions that are good for the economy or good for business. That's just not true. It's our longstanding precedent that will be able to help businesses and communities and people be able to thrive.
Thank you so much, Sky. I really appreciate that. A question for Kirti from Inside Climate News. What could this mean for the large number of climate-related regulators and regulations that are now in process, power plant and vehicle emissions? Have the EPA and other regulators already anticipated a Chevron challenge? And have you seen signs that they're working to address a post-Chevron world in these types of rulemakings?
I can't speak for anybody who's in an agency GC's office, but I think I would be shocked if the following isn't true. So I think, first of all, agencies already have probably spent a lot of time thinking about how to deal with West Virginia versus EPA and the major questions doctrine, which, although it's a separate issue from Chevron, it's a rule about how to interpret statutes, and it's a rule that sort of dramatically increases the litigation risk around regulations. And then I would add that in recent Supreme Court decisions, we have seen the language from West Virginia versus EPA creep into ordinary statutory interpretation decisions. So things like, this seems like a big stretch, or the agency hasn't done this before, things like that. So it's sort of already infected the ordinary task of interpreting and executing statutes. And so my assumption is that, along with what I said about at the beginning, that the Supreme Court has at least been sending a signal that it's not that interested in applying Chevron. So at the very least, in sort of high stakes regulations that might end up at the court, I would assume that agencies have already been, assuming that they shouldn't, have step one or phase one of their defense of their regulation be about Chevron. And then I would just add that there are all these other developments that are happening outside the context of these two decisions that are probably shaping agency actions in the same exact way that they would be shaped when you're thinking about a world post Chevron. So I guess my basic answer is I assume the answer is yes, and that it might go deeper than the question might have assumed.
Can I just jump in? I worked for the government at the Solicitor General's office and litigating the Courts of Appeals as my prior life. And I also worked for then Judge Merrick Garland in the DC Circuit and saw a lot of administrative law kind of at that level. And I just really want to agree with what Kirti was saying. People have been preparing for this for a long time. And nevertheless, I think this is still a momentous decision for a lot of the reasons that echo what I think she was saying. This case will then be one that can be cited in other areas as more efforts to tear away at the administrative state and to tear away at good governance and effective governance, because there are ideological forces that have been mustering for a long time, several years now, appointing justices to the Supreme Court, making arguments and winning arguments in the Supreme Court that have made Chevron a roughly toxic precedent to cite and rely on, just exactly, again, as Kirti was saying. So I just want to say, from sort of the government side of things, I think that everything she was saying is totally right. And nevertheless, I think that in the same way the major questions doctrine has had ripple effects damaging government across many spheres, everyone should expect that the Chevron deference doctrine, which is cited in agencies every single day for the last 40 years, that's the kind of thing that will also have that same sort of cowing effect that'll prompt all the litigation just exactly the way folks are talking about.
No, I appreciate that, and I saw you champing at the bit to get to major questions, which if we have time, want to get everybody's thoughts on major questions, and also to keep it within the context, Jarkessi and the upcoming Corner Post case, which could be even worse than Chevron. But just briefly, Craig, could you, there has been a paradigm shift in the way that conservatives have looked at Chevron going back 1984. It was a conservative opinion up until 2011, 2012. Justice Thomas was one of its largest proponents. He expanded in 2001. What's changed in the last 10, 15 years?
Yeah, so I myself have written tens of thousands of words on that exact question, charting the shift of conservative jurists from one to the other. So here's like the tiniest version. Chevron was a case brought for a regulation of Ann Gorsuch, Neil Gorsuch's mom. Then Judge Ruth Bader Ginsburg on the DC Circuit voted against it and got overturned because she was doing judicial precedent, needed to defer. All the politics were upside down. I tell my students, all of us should be looked at with the love that Nino Scalia felt for Chevron. Justice Scalia, a conservative icon, loved Chevron more than any other. Thomas has absolutely shamelessly flip-flopped. He used to love Chevron and now he has come to hate it. And I think the pivotal year is 2013. And that's a peculiar year, as it turns out. But you try to explain 2013, you see, of course, 2013 is a second Democratic presidential victory. And I think you see a lot of folks who used to like a lot of presidential power, then they flip over and maybe they don't like it quite so much. Or they have ideas about they can do things in courts they didn't think they could do before. Justice Scalia grew up as a lawyer in a world where lots of left-wing judges, but actually today there are a lot of right-wing judges and they have new legs under them and they have more force and more power and they can see things that they can do without resorting to elections or whatever. So I think there are a lot of things that have changed, but I think it is absolutely a long arc trajectory, a lot of different doctrines woven together, but Chevron really is, in a lot of ways, the keystone of the whole thing. Like, it really represents something important. And so I think it fits in with this larger trajectory as, conservatives taking the wheels off the wagon and using courts and constitutional law, new constitutional law, to undermine a lot of projects that have been taken for granted as basic parts of American fabric of life, safety and so forth.
That's amazing. And I do love that point about new constitutional law. We're not following stare decisis. We're not following precedent that dates back decades, if not centuries. We're just, as you said earlier, this new 6-3 court has decided, oh my God, nobody noticed that this was unconstitutional for the past 80 years. We're running out of time, so I want to go around the horn with one last question, and we'll start with Sky. Is there anything that we should be doing about what the court is likely to do from a congressional standpoint, from a stakeholder standpoint, from a regulatory standpoint? And I spread it that wide because we're all in different spheres. So please just tackle it as you can.
Well, I'll just say, we don't know what the court's going to do. And so we obviously first have to urge, as many on this call and others representing parties have done, that the court affirm the law and affirm this, many years of precedent. But in a world where it doesn't, and this leads to a disruption, there is work that needs to be done now. Overturning Chevron does not mean that federal agencies would not have some type of role, and it doesn't mean that Congress won't have a major, they continue to sort of have a major roles with their policy making and the authority that they give federal agencies. And so a lot of work, I know you yesterday, Devin, were briefing some folks on the Hill. I mean, a lot of work to start educating our allies, to start educating policymakers, to make sure that people understand that while this is something arising in the marine fishing context, this could have broad sweeping implications for all of the work that people do, their industries and their organizations. So I would just urge for those that are listening and that want to understand how to prep and be ready, for them to get in touch. And I know you have some contact info with the webinar, but to reach out, because there is work going on. And I do think that it's quite important that policymakers and agency officials start thinking about what the scenarios will look like if there is a disruption in this precedent, and the work that can be done to document and to further modify the way we do policy making.
Thanks. I'll popcorn over to Kirti.
Yeah, I think I just want to pick up on a thread of what Sky, or what I took Sky to be saying, which is I think that if Chevron is overturned, combined with all the other sort of attacks from various angles that Craig and others have mentioned, I think it'll be totally reasonable for somebody sitting within an agency to say, like, I only have X amount of time to achieve, Y amount of things. And if I, even if I think this is the best interpretation of the statute and it allows me to pursue this policy through regulation that will help a lot of people, I think it's probably going to get struck down in the courts. And so I should do instead this smaller thing that will help less people, but might survive. And I completely understand and am empathetic with that. And I think the reaction to that from our communities has to be to continue to push agencies to carry out the best reading of the statute, what we think that means, and to pursue policies that might have big effects despite that litigation risk, and to do it smartly. There's all sorts of things you can do to insulate a regulation from challenge, but to not fall into that problem that I think Sky mentioned in her intro, and others have also touched on, of allowing these kinds of doctrinal shifts to shrink government sort of out of fear and lead into this cycle of government doing less and less and people believing less and less in government. So I think the student loans case provides a pretty good example of that, right? The government tried to do something on student loans, the Supreme Court struck it down, the government tried to do something else, right? That kind of perseverance and commitment to the policy goals and the legal interpretations that underlie them is, I think, the model that we have to follow in the future.
We're going back to a Rooseveltian edict: try something. If it doesn't work, try something else again, but no matter what, keep trying. And this effort is to roll back everything that FDR put in place 90 years ago, unfortunately. Andrew.
I would say a couple of things. I think, first of all, I don't think we should be assuming that Chevron is dead. And I think that it's really important, because I think that we've seen that the Supreme Court is responsive to public opinion. And if you give them a pass and say, like, oh, that's already been, banked, that's already been counted, then they'll say, oh, okay, we've already gotten permission to do this. And I think that we don't want to give them permission to do this. And I think that there's also, as I said at the outset, there's so many different ways that regulations, make us all safer. And I think that there's, I don't think all the Supreme Court justices, or at least maybe not, 5 of them or 6 of them, all want to live in a world where the FDA, for example, doesn't have the authority to recall a medication because it's not safe, and I think that they also are starting to recognize that, as far right as the Supreme Court is, there's, there are district court judges and circuit court judges that are even further right than they are, and will happily strike down, regulations that they think are reasonable. And I don't think they want to live in that world where, you have random, district court judges across the country who are imposing their view and therefore, issuing nationwide injunctions that stop regulations in their tracks. So I think, those are the points I think that we need to sort of keep making, is this is not a world where people you know, the vision that's being put here is not the vision of the world that most people in this country want to live in.
I agree. Sarah.
I can't top that. I think that's exactly right. And I cannot agree enough with Kirti. Just keep fighting, keep doing it, and don't let them cow you, because that's half the game. And also, let's just see what happens next week. What does the argument sound like? And let's see what they decide.
Fair enough. Craig, bring us home.
Understand the truth, which is what this seminar is about, what people came here to hear about, seeing through some of the muddiness and the arcanity and so forth. And the other thing is voting. So I think that, having an agency that perseveres depends on having an agency with a certain point of view, having judges who will vote a particular way or have a certain constitutional philosophy. Those are all ultimately decided by elections. They have been decided by elections. They will be decided by elections. And I think that's a way in which the law and the real world come together in this particular moment we're facing.
All right. Well, I don't disagree, and I think if you talk to most Americans and you tell them what agencies actually do and the protections they provide, they are going to be opposed to these types of things. So there's a lot that we didn't get to talk about today. Non-delegation doctrine, the zombified thing that is coming next, corner post. Stay tuned for more with CAP, but thank you to Andrew Strom, Sky Perryman, Kirti Datla, Craig Green, Sarah Summers. Fantastic panel, and thank you to those of you who tuned in today. Please check out CAP's website. We've got some great explainers, some great one-pagers that really outline what is at stake in this and other cases this term, because they're really coming after all of the things that protect everyday Americans and that a lot of Americans take for granted. So thank you guys so much, and we'll see you next time.
Thank you.